Be ready for dictation. 5 seconds.
Start. Learned AGA has opposed the bail application and submitted that huge quantity of contraband (ganja) has been recovered and the applicant was sitting in the DCM truck when the alleged recovery was made. He further submitted that sample from each 8 bags of ganja recovered was sent for chemical analysis which amounted to 80 grams on 18/11/2023. The report of FSL was submitted on 2/12/2023 which has been annexed as Annexure 1 to counter affidavit. According to him, charge sheet was submitted on 31/12/2023 and cognizance order was passed on 12/1/2024. According to him, FSL report is part of the case diary dated 19/6/2024 as the investigation is still going on in respect of the owner of the vehicle, which is evident from CD8 prepared on 31/12/2023. He then contended that FSL report is only a corroborative evidence which shall be considered at the time of trial. The argument raised from the applicant's side that it is not part of case diary is not acceptable. He further contended that Section 293 of the Code of Criminal Procedure 1973 provides for report of certain government scientific expert which includes examination or analysis, and report is course of any proceeding under the code and may be used as evidence in any inquiry, trial or other proceedings under the code. He also contended that provisions of Section 167(2) CRPC in case of commercial quantity have been recovered of any contraband would be read as 180 days and not as 90 days. This has been provided in Section 36A(4) of the NDPS Act 1985. I have heard respective counsel for the parties and perused the material on record. Before adverting to decide the second bail application is cursory glance of recent judgment rendered by Honorable Apex Court in case of Narcotics Control Bureau versus Kasif in Criminal Appeal number 5544 of 2024 arising out of special leave petition (criminal) number 12120 of 2024 decided on 20/12/2024 is necessary for better understanding of the case. Honorable Supreme Court, considering the legislative intent and the history of the NDPS Act and insertion of Section 52A, held that the heading of Section 52A itself leave no room of doubt that the provision was inserted for an early disposal of the seized narcotic drugs and psychotropic substances as one of the measures required to be taken to implement the provisions of the International Conventions on Narcotics, Drugs and Psychotropic Substances. Relevant paras 20, 21, 23 and 24 of the judgment are annexed here as under. Now, so far as Section 52 is concerned, the language employed therein itself is very clear that the said provision was inserted for an early disposal of the seized narcotic drugs and psychotropic substances, having regard to the hazardous nature, vulnerability to theft, substitutions, constraints of proper storage, space and other relevant considerations. Apart from the plain language used in the set section, its heading also make it clear that the set provision was inserted for the disposal of the seized narcotic drugs and psychotropic substances. As per the well settled rule of interpretation, the section heading or marginal note can be relied upon to clear any doubt or ambiguity in the interpretation of any provision and to discern the legislative intent. The section heading constitutes an important part of the Act itself and may be read not only as explaining the provisions of the section, but it is also affords a better key to the constructions of the provisions of the section which follows than might be afforded by a mere preamble. Full stop over.